Hi, my name is Angela Huggins. I'm with Green River Property Management, and today I'm going to talk to you about the reasonable accommodations under the Fair Housing Act and how that applies to tenants and landlords. Reasonable accommodations are when a landlord or housing provider would make changes to standard policies and procedures and or rules to accommodate a person with a disability. And the Fair Housing Act defines a person with a disability as an individual with physical or mental impairment that substantially limits one or more major life activity. And it's really intended to make a person feel comfortable and safe living in their home. The accommodation is the requirement of the landlord. The modification then comes into play for the tenant. The modification is a structural change that would impact the interior or exterior of the home, and it is the tenant's responsibility to make the changes as well as be able to accommodate and pay for them to be restored back to their original condition, and if that is a reasonable thing to do. And the Fair Housing Act defines that kind of loosely, but would kind of give examples such that if a person in a wheelchair had to expand a door frame to fit their wheelchair, that it would not be reasonable to ask them to restore that to its original condition to make it more narrow when they were to leave the property. It is important to note that any exterior changes that are made by a tenant are not required to be restored back to their original condition. It's also important to note that any request can be made by a tenant before or during tenancy at any time, and any housing provider or landlord cannot deny or restrict housing or access to housing or these requests, as it would be considered discrimination. So if you have any questions about this or would like some more information, we'd be happy to answer it for you at Green River Property Management.